I built this barbecue joint with my own two hands. 19 employees, 3 generations of my family, 67 years feeding this town. Then one random Tuesday, a woman who had never taken a single bite of my food walked in and slapped a lawsuit on my counter. She wasn't sick. I didn't break any law. She demanded I shut the whole place down because the smell of my barbecue was causing her psychological suffering. $340,000. That's what she thought my grandfather's life work was worth. Here's what'll make your blood boil. The city knew about her. The health department knew about her. And they let her keep coming after me anyway. But when the judge finally threw her case out, she completely lost her mind. What would you do if someone tried to destroy everything you built over the smell of smoked brisket? Drop your city below. I'm reading every comment. Let me back up because you need to understand what Braddock's Smokehouse actually means before you can feel the full weight of what Cordelia Fitch tried to do to it. My grandfather, Wendell Braddock, came home from Korea with 2 things, a Purple Heart and a cast iron smoker he welded together in his garage from a cut-down propane tank. He started selling pulled pork out of his driveway on Saturdays in 1956. Neighbors brought folding chairs. People brought potato salad. It was a community thing before anyone called it that. By the time my dad, Harlan Braddock, took over in 1981, Wendell's Smokehouse had 4 walls, a liquor license, and a loyal following that stretched from the plant workers over on Route 9 all the way to the county sheriff's department. I'm Gideon Braddock, 3rd generation. I grew up scrubbing grease traps on Saturday mornings, learning how to trim a brisket by feel, and sleeping in the back booth when my parents worked late. The smell of hickory smoke is it's my childhood. It's every good memory I have. When my dad handed me the keys in 2017, I'd already spent a decade paying my dues. I added a covered patio, upgraded to 2 custom-built offset smokers the size of a small sedan, and tripled our weekend revenue within 3 years. We employed 19 people full-time. 11 of them had been with us more than 5 years. Our head pitmaster, a guy named Theo Duquesne, had worked for us since he was 17, straight out of high school, worked his way up, bought a house 2 streets over, put his daughter through nursing school on the wages we paid him. That's what Braddock's Smokehouse was, not just a restaurant, an ecosystem. Now, Cordelia Fitch. She moved to Millhaven from Portland, Oregon, about 18 months before all this started. She was in her late 40s, loud about her veganism, in the specific way that suggests it isn't really about the food. It's about identity, status, something to wave. She founded a local chapter of an animal rights group called Compassion First Coalition, which mostly seemed to exist on Facebook and in the comments section of the Millhaven Gazette. She organized a protest outside the Millhaven County Fair when they announced a rib cook-off. She tried, and failed, to get the school district to remove hot dogs from the cafeteria menu. She was, to put it charitably, persistent. To put it accurately, she was a boulder rolling downhill looking for something to flatten. The first time she came into Braddock's, I thought it was a mistake. She sat at the counter, looked at the menu like it had personally offended her ancestors, and ordered a side salad and sweet tea. Fine. We have vegetarian sides. I'm not trying to convert anyone. But instead of eating and leaving, she spent 45 minutes photographing the smokers through the window, scribbling in a notebook, and asking my waitress, Patrice, pointed questions. Do you know how these animals are raised? How does it feel to serve this every day? Patrice is a 43-year-old grandmother from Millhaven who has been serving food since she was 16. She does not need a visitor from Portland asking her how her job makes her feel. Cordelia left a 2-star Yelp review that said, and I quote, "The atmosphere of suffering is palpable." She came back the next week and did it again, and the week after that. Each visit generated another review, another Facebook post, another passive-aggressive complaint to the Millhaven Health Department, which inspected us twice in 6 months and found 0 violations because we run a clean ship. I shrugged it off. Difficult customers are part of the business. I've dealt with worse. I should not have shrugged it off. The first real shot Cordelia fired came on a Friday evening in late September. Braddock's was packed. There's a high school football game every Friday night during the fall, and we get half the town afterward. Bleacher dust still on their jeans, the smell of concession stand popcorn mixing with our hickory smoke. I was behind the counter, expediting, when Patrice leaned over and said, "Gideon, there's a woman outside with a sign." Cordelia had stationed herself on the public sidewalk in front of our parking lot with a 4-foot poster board that read, "Braddock's equals animal torture, funded by your dollars." She was handing out photocopied flyers to people getting out of their cars. 2 or 3 people looked embarrassed and walked past quickly. A handful of folks stopped to argue with her. One of our regulars, a guy named Prentice Holloway, who drives a delivery truck for a living and orders the same brisket sandwich every Friday without fail, took a flyer, read it, folded it deliberately into a tiny square, and dropped it in the trash can right in front of her. "Nice paper," he said. "Wasted." I could have kissed him. Here's the thing. She was within her rights. Public sidewalk, peaceful protest, no threats, no blocking access. I know my First Amendment. I called our town's non-emergency line just to document the event, and the officer who showed up took one look at the situation and told me there was nothing they could do. He was apologetic about it. "She's not doing anything wrong, Mr. Braddock, just loud." So I adapted. I set up a folding table just inside our front doors with free samples, little plastic cups of our smoked brisket and our sweet tea glazed ribs. Every person who walked past Cordelia's sign and came inside got handed a taste before they even reached the hostess stand. Our Friday revenue that night was the highest we'd recorded in October in 4 years. The smell of oak smoke and char and brown sugar bark drifting out our propped open front door probably didn't hurt. Sometimes the best counter-protest is just a really good brisket. But Cordelia noticed. The following Monday, she filed a noise complaint with the city, claiming our exhaust vents were excessively loud and were being used to project meat odors onto unwilling pedestrians. I am not making that up. She actually used the phrase meat odors onto unwilling pedestrians in an official city complaint. The city inspector came out, measured our exhaust fan decibel levels, confirmed we were well within code, and closed the complaint. But it cost me an afternoon, and more importantly, it cost me a city inspector's time, which told me something about Cordelia's strategy. She wasn't trying to win individual battles. She was trying to tie me up in bureaucratic quicksand, one complaint at a time, until I was exhausted enough to make a mistake or just give up. My response? I went to see Walt Gervais. Walt is a semi-retired attorney in Millhaven who handled my grandfather's original business incorporation and my dad's lease renewals for 30 years. He's in his early 70s, drinks black coffee from a thermos the size of a fire extinguisher, and has the kind of quiet legal confidence that only comes from watching every possible human foolishness for 4 decades. I spread the complaint paperwork on his desk and told him the whole story. Walt pushed his glasses up and read through everything without a word. Then he said, "Start a file. Every complaint, every date, every inspector visit, every Yelp review that contains a factual inaccuracy. Build a paper record, because this woman is not done." He was right. 2 weeks later, the Millhaven Gazette ran a front-page story, and I use the word story loosely. That was essentially Cordelia's press release reformatted as news. The headline, "Local Restaurant Draws Animal Rights Concerns." The article quoted Cordelia extensively, included a photo she had provided of her protest sign, and mentioned my restaurant by name 7 times. In the entire piece, I got one sentence: Braddock Smokehouse did not respond to requests for comment, which was false. I had emailed the reporter a 3-paragraph statement the morning he called. He simply didn't run it. I emailed the editor a formal correction request. They published a 2-line update buried on page 8. My regular customers were furious on my behalf. 3 of them wrote letters to the editor that ran the following week. One of them, a retired school teacher named Eugenia Wakefield, wrote a letter so eloquent and pointed that it got shared 300 times on the Millhaven Community Facebook page. I printed it out and taped it to the wall behind the register. Cordelia had made a tactical error. She'd given me something more valuable than a correction. She'd given me proof of community support, and Walt Gervais had now started a very thick file. Cordelia leveled up in November, and she did it using a tactic I genuinely did not see coming. She formed a coalition. Not a big one, maybe 15 or 20 people, mostly recent transplants to Millhaven, and a handful of college students from the agricultural extension campus 12 miles away. But she gave it a real name, the Millhaven Ethical Consumption Alliance, registered it as a non-profit, got a proper website with a donation button, and started attending city council meetings. The meetings in Millhaven happen on the first and third Tuesdays of each month in a beige room at the municipal building that smells of industrial carpet cleaner and somebody's leftover lunch. They're sparsely attended. Usually the same 15 people who care about zoning and the water treatment facility budget. Cordelia showed up with 8 members of her alliance and spoke during public comment for the full 3 minutes she was allotted, every single meeting. She never yelled, she never threatened. She was calm, articulate, and relentless. She argued that the city's commercial zoning ordinance, specifically Section 12C, which governs odor and particulate emissions from food service operations, was being insufficiently enforced against Braddock's Smokehouse. She brought printed EPA studies about particulate matter. She brought printed testimony from residents who claimed to live downwind of our smokers and experience health effects. I want to be clear. Our restaurant sits on a commercial block surrounded by a tire shop, a hardware store, and a Mexican restaurant that uses more jalapenos per square foot than any establishment I have ever encountered in my life. The idea that our smokers were uniquely fouling the air of residential Millhaven was absurd. But she said it calmly, with footnotes, in front of elected officials. The council chair, a cautious man named Alderman Philip Sowerby, didn't dismiss her. He said the city would look into the matter, which, in local government language, means we will create a subcommittee that will produce a report that nobody will read. But it was enough for Cordelia to put out a press release claiming the city was investigating Braddock's Smokehouse. My response this time was not just Walt Gervais. I went on offense in the public arena. I attended the next city council meeting. I brought Theo Duquesne, my head pitmaster, who was the most composed man I've ever met. I brought Patrice, my waitress. I brought a folder of our last 3 environmental compliance certificates, our health inspection records, and a stack of utility bills showing our exhaust filtration system had been upgraded in 2021. I also brought 19 signed letters from employees, 42 signed letters from customers, and a notarized statement from our nearest residential neighbor, a woman named Mrs. Oberholt, who has lived in the house adjacent to our parking lot since 1974, saying that she had never been bothered by our smokers, that she in fact found the smell pleasant, and that she had eaten our food approximately twice a month for the better part of 30 years. When it was my turn to speak, I didn't attack Cordelia. I spoke about the history of Braddock's Smokehouse. I talked about Wendell and the cast iron smoker. I talked about the 19 jobs. I talked about the $40,000 our restaurant had contributed to the Millhaven High School Athletics Booster Fund over the past decade through our annual fundraiser nights. I talked about Mrs. Oberholt. I spoke for exactly 2 minutes and 58 seconds, 2 seconds under the limit. The aldermen sat very still. 2 of them were nodding. Alderman Sowerby thanked me and said the city's review had found no actionable violations. He did not look at Cordelia when he said it. Cordelia did not let it go. After the meeting, she caught me in the parking lot, the gravel crunching under her sensible shoes, the cold November air carrying the exhaust from the building's heating unit, and she looked me dead in the eye and said, "This isn't over, Mr. Braddock. There are legal avenues you haven't considered." "I look forward to them," I said, and I meant it. 2 weeks later, in the first week of December, the letter arrived. Cordelia Fitch, represented by an attorney from Columbus named Reed Albright, was suing Braddock's Smokehouse, LLC, Gideon Harlan Braddock, personal capacity, and the city of Millhaven for nuisance, discriminatory business practices, and, I had to read this 3 times, intentional infliction of emotional distress upon members of the vegan and animal rights community. The claim damages $340,000. I set the letter down on my prep counter. Theo leaned over, read it, and said exactly 1 word. "Seriously?" "Seriously," I said. I called Walt Gervais. He was quiet for a moment and then said, "Good. Now we can actually fight back. Let me tell you something about being sued that nobody warns you about. It's not the fear that hits first. It's the absurdity. You're standing in a restaurant that your grandfather built, that your father expanded, that you have poured your literal blood and calluses into, and you're reading a legal document that argues your brisket is a hate crime. The surreal quality of it makes you want to laugh. Then, about 20 minutes later, the fear shows up. I called Walt, who called his colleague Nadine Ostrowski, a litigation attorney in Columbus who specialized in what she called nuisance suppression, that is, defending small businesses against exactly this kind of claim. Nadine was sharp, efficient, and had a voice that sounded like she'd spent 30 years not losing arguments. She drove down to Millhaven the following Saturday, sat across from me at the big round table in our dining room, ordered coffee, and read through the entire complaint while I watched. When she was done, she put it down and looked at me. "This lawsuit is what we call a SLAPP suit," she said. SLAPP stands for Strategic Lawsuit Against Public Participation. Here's the layman version, and this is important, so lean in. A SLAPP suit is a lawsuit filed not because the plaintiff expects to win in court, but because the act of filing the lawsuit causes harm to the defendant. Legal fees, time, stress, reputational damage from the mere fact of being sued. The goal isn't a verdict, the goal is exhaustion. The plaintiff drops the suit long after the damage is done. Takeaway. SLAPP suits are a recognized legal weapon used to silence people, and over 30 states have passed anti-SLAPP statutes specifically to stop them. Ohio is one of those states. Ohio Revised Code Section 2923.14, look it up, provides that a defendant in a SLAPP suit can file a special motion to dismiss early in the proceedings and, if successful, can recover attorney's fees from the plaintiff. In plain English, if we could convince a judge that this lawsuit existed to intimidate rather than to remedy a real legal harm, Cordelia and her attorney would owe us money. Nadine filed our anti-SLAPP motion within 10 days of being retained. She also filed a counterclaim, a formal legal allegation that Cordelia's pattern of complaints, the manufactured press coverage, the coordinated city council appearances, and now this lawsuit constituted an intentional, coordinated campaign to harm a legitimate business through abuse of legal and administrative processes. That's called tortious interference with business relations. Another thing you can Google. Takeaway. Tortious interference is a real civil claim that can make a harasser financially liable for the business harm they deliberately cause. Cordelia's attorney, Reed Albright, clearly had not expected a counterclaim. His response filing was, how to put this, flustered. He argued our anti-SLAPP motion was procedurally premature and that our counterclaim was retaliatory. Nadine's reply brief, which I read in its entirety, and which I can only describe as a controlled demolition, pointed out that a counterclaim responding to a lawsuit is by definition not retaliatory. It's responsive. But here is where Cordelia made her biggest mistake. Her complaint, enlisting the basis for emotional distress damages, alleged that members of her organization had experienced ongoing psychological harm from Braddock's Smokehouse's deliberate and theatrical display of smoked meats in its front window. She was referring to our display case, a refrigerated glass case near the entrance that shows our whole packer briskets and racks of ribs before service. It's been there since my grandfather's time. It's essentially our logo. But here's what Cordelia didn't know, or didn't check. That display case and the window it sits behind are specifically described in our commercial lease agreement as a protected business feature, a term our property manager had added back in 2008 after a previous tenant dispute. Our lease with the Millhaven Commercial Properties Group, which is owned, incidentally, by a man named Donald Fessler, who has eaten at Braddock's every Thursday for 15 years, guaranteed our right to use the storefront display for food merchandising in perpetuity, regardless of neighbor or third-party objection. In other words, the centerpiece of Cordelia's emotional distress claim was something we had a contractual right to do, and that right was in writing, notarized, and had been in force for 16 years. Walt called it the gift they didn't know they handed us. Nadine called it the end of the lawsuit. She was being optimistic. There were still months of procedural grinding ahead. But she wasn't wrong about the direction. Meanwhile, the people of Millhaven had heard about the lawsuit. Small towns talk, and they were angry. Right around the time Nadine was drafting our anti-SLAPP motion, Walt Gervais pulled something out of his file cabinet that I had completely forgotten about. In 2019, Cordelia Fitch, 2 years before she moved to Millhaven, had been the named plaintiff in a nearly identical lawsuit against a steakhouse in Portland, Oregon, called Red Timber Grill. The suit alleged nuisance and emotional distress. The Oregon court dismissed it under Oregon's anti-SLAPP statute. The Red Timber case, from beginning to dismissal, had taken 11 months and cost the owners approximately $28,000 in legal fees that they never fully recovered. So Cordelia was not a first-time crusader. She was a repeat player. She had a methodology. Find a meat-based food business in a community where she had social standing. Build a harassment record. File a lawsuit. Wait for the exhaustion. The Red Timber owners had not filed a counterclaim. They just tried to get the case dismissed and move on. It worked legally, but they were broke and burned out, and they sold the restaurant 18 months later. Cordelia had not technically won in Oregon, but she had achieved the functional outcome she wanted. Walt had found this through LexisNexis, a legal research database you can access through most public university libraries, for free, if you know how to ask the reference librarian. He found the case citation, pulled the full dismissal order, and handed me a printout over coffee on a Tuesday morning. I sat there for a long time reading it. The names were different, the city was different, the details were different, but the structure, the pattern of administrative complaints, the media pressure, the lawsuit, was identical. She had run this play before. Here's why that matters legally. Prior similar conduct by a plaintiff is admissible as evidence of intent and pattern in a civil case. If Cordelia's attorney was arguing this was a genuine, good-faith complaint about public health and animal welfare, we could now introduce the Oregon case to show a documented pattern of using litigation as a harassment tool. Her lawsuit was not idealism, it was a franchise. Nadine added the Oregon precedent to our counterclaim immediately. But Walt pointed out something else. The Compassion First Coalition, Cordelia's national organization, was the institutional donor to her local Millhaven group. They were funding her activities, including, presumably, her legal fees. Nadine filed a discovery request, asking for all financial records between Cordelia Fitch, the Millhaven Ethical Consumption Alliance, and the National Compassion First Coalition. This was a legitimate request. If the national organization was directing and funding the lawsuit as a coordinated campaign, they might bear liability alongside Cordelia personally. The discovery request made Reed Albright very quiet for about 2 weeks. Then he filed a motion to quash, arguing the financial records were protected as organizational speech under the First Amendment. Nadine filed a response pointing out that financial records in a civil litigation are almost never shielded from discovery, and that the Supreme Court had addressed exactly this issue in cases involving coordinated campaign activities. The judge, Judge Harriet Voss, a former county prosecutor in her early 60s who had the patient, slightly tired energy of someone who had seen every legal maneuver twice, scheduled an expedited hearing. Cordelia had come to Millhaven to run a familiar play. She had not expected anyone to know the script. January in Ohio is cold in a way that doesn't make the news because it's not dramatic. It's just relentless. The sky is the color of old concrete, and the wind off the flatlands comes through your jacket like it has somewhere to be. Braddock's heaters run full blast, and the windows fog from the inside, and the place fills up earlier in winter because people want somewhere warm that smells good. We were packed, but I was running 2 tracks simultaneously, keeping the restaurant alive and building our legal and public case. On the legal side, Nadine was methodical. The anti-SLAPP motion was filed and briefed. The counterclaim was in place. Now we needed to document everything Cordelia had cost us. Nadine walked me through the process of calculating economic damages for a tortious interference claim, and it came down to a pretty clear formula. Take our average weekly revenue before Cordelia's campaign began, compare it to our revenue during the campaign period, and the gap is your provable harm. We had detailed POS records going back 6 years. Our December revenue, the month the lawsuit was filed, which coincided with local news coverage of the complaint, was down 18% from the same month the previous year. I hadn't made the connection consciously, but the numbers didn't lie. The press about the lawsuit had scared off some customers. That was quantifiable. Takeaway: if someone's harassment campaign causes you measurable revenue loss, keep meticulous records. Every receipt, every sales report, every slow Tuesday. Because those numbers are your damages in a civil claim. On the community side, something was happening that I hadn't engineered, but was watching with something between gratitude and awe. The people of Millhaven were organizing themselves. Eugenia Wakefield, the retired school teacher whose letter to the editor had gotten 300 shares, started a Facebook group called Friends of Braddock's Smokehouse. Within 3 weeks, it had over 800 members in a town of 12,000. People were posting old photos, birthday parties at Braddock's, anniversary dinners, photos of their parents at the original diner version in the 1970s. One man posted a photo of his grandfather shaking hands with my grandfather, Wendell, in 1962, both of them grinning in front of that original propane tank smoker. I had never seen the photo before. I had the man scan it, and I put a print of it on the wall next to Eugenia's letter. Theo Duquesne, my pitmaster, organized what he called a smokeout for Braddock's, a community cookout in our parking lot on a Saturday in late January. He called in favors from 3 other local barbecue enthusiasts, borrowed 2 extra smokers, and we ran a pay-what-you-can lunch that donated all proceeds to the Millhaven High School Culinary Arts program. 240 people showed up. The parking lot smelled like charcoal and apple wood and the bite of cold air, and there were kids running between the smokers and families sharing folding tables, and it was, genuinely, one of the best days I can remember. The Columbus Dispatch sent a reporter, not because of the lawsuit, because of the community response to the lawsuit. The story ran as a feature. Millhaven Barbecue Institution fights back, rallies town. It ran with a photo of Theo at the smoker, tongs raised, expressions serene. His daughter, the nurse, texted him from Cincinnati, "Dad, you're famous." He showed me the text and laughed in the quietly pleased way he does everything. On the physical side, and this is where I want you to pay attention because this was deliberate, I made one very specific strategic decision about the restaurant itself. I expanded the display case, not dramatically. I added one additional refrigerated case on the opposite side of the entry foyer, displaying our whole rack ribs and full packer briskets, with better lighting and a printed menu card describing our sourcing. I added a sign, "All meat sourced from Ohio family farms." I did this not out of spite, but out of principle. If Cordelia's lawsuit was going to put a spotlight on my display case, I was going to make it worth looking at. I also, on Walt's advice, hired a licensed professional engineer to perform a documented emissions test on our smokers and filtration system. The engineer produced a 17-page report concluding that our particulate emissions were 34% below the applicable Ohio EPA standard for commercial food service operations. We had that report notarized and filed with the city. We were not just defending, we were building an anvil to drop. Cordelia must have felt the momentum shifting, because in February she changed tactics in a way that told me she was scared. She reached out to a food blogger named Tiffin Marsh, who runs a moderately popular sustainability food Instagram and YouTube channel out of Cincinnati. Maybe 60,000 followers, the kind of micro-influencer who gets invited to restaurant openings and writes about conscious eating. Tiffin came to Millhaven, toured Braddock's exterior with a camera crew of 1. She did not come inside, did not request access, did not speak to me, and produced a 20-minute YouTube video called "Why This Ohio Barbecue Restaurant is Being Sued and Why It Matters." The video was largely Cordelia's perspective, presented as journalism. My restaurant was shown from outside, always at angles that made it look ominous. There was dramatic background music. There was a segment where Cordelia cried. I watched the entire thing with Nadine on a laptop in my office, which smells of paper and old grease from the vent above the fryer. And when it was done, Nadine said, "That's going in the counterclaim." The video contained at least 4 factual inaccuracies she could identify on a single viewing, including the claim that Braddock's had failed multiple health inspections, a flat-out lie. Nadine drafted and sent a cease and desist to Tiffin Marsh's business email within 48 hours, citing defamation per se, statements false in fact that damage a business's reputation. Tiffin took the video down 4 days later and posted a brief correction. Cordelia escalated again. She contacted 3 of our Ohio-based meat suppliers, small family farms we'd worked with for years, and sent each of them a letter on Millhaven Ethical Consumption Alliance letterhead, informing them that they were party to ongoing litigation against Braddock's Smokehouse and suggesting they consider the reputational implications of continued association with a defendant business. This was a bluff. Our suppliers were not named in the lawsuit, but it was designed to make them nervous enough to stop selling to us. 2 of the 3 suppliers called me directly. They were not nervous. They were furious. One of them, a cattle rancher named Boyd Calloway from Knox County, sent a handwritten letter to Nadine, offering to provide a sworn affidavit describing the contact he'd received from Cordelia's organization. He wrote, at the bottom in heavy pencil, I have been raising cattle on this land for 38 years, and I will not be lectured about my business by someone who drove in from Portland. I have that letter in my own file now. The supplier intimidation attempt had two unintended effects. First, it gave Nadine additional evidence of a coordinated harassment campaign extending beyond the lawsuit itself, further supporting our tortious interference counterclaim. Second, it made Boyd Calloway a potential witness for our side. In law, when you reach out to someone in an attempt to damage your opponent's business relationships, and that person then becomes a willing witness against you, lawyers have a term for this. It's called own goal. Meanwhile, Judge Voss issued her ruling on the discovery dispute over Cordelia's financial records. She denied the motion to quash. The financial records of the Millhaven Ethical Consumption Alliance and its communications with the National Compassion First Coalition were ordered produced within 30 days. Nadine called me from her car, voice even but pleased. "We're going to see the receipts." The receipts, when they came, were illuminating. The National Compassion First Coalition had wired $15,000 to the Millhaven chapter, specifically earmarked for legal action initiatives, in the 4 months before Cordelia filed her lawsuit. They had email exchanges discussing Braddock's Smokehouse by name. They had a strategy document titled Millhaven Action Plan that outlined the sequence of administrative complaints, media pressure, and ultimately litigation in a timeline that matched, almost exactly, what Cordelia had done. This was no longer a story about one person's conviction. This was a coordinated organizational campaign funded by an outside group to destroy a small family business, using litigation as a weapon. And we had it in writing. Nadine amended our counterclaim to add the National Compassion First Coalition as a defendant. Reed Albright's office went very, very quiet. March arrived with mud season, and the smell of thawing earth coming through the back door of the kitchen every morning. I was running on 4 hours of sleep and more coffee than is medically advisable. The lawsuit was approaching the anti-SLAPP hearing date, April 12th, and Cordelia made one final push, the most personal one yet. She started targeting my employees. Members of the Millhaven Ethical Consumption Alliance began showing up at the homes of my staff, ringing doorbells, and leaving informational packets about animal agriculture. They left materials in the windshields of cars parked in front of my employees' houses. One of the Alliance members posted on social media, asking followers to kindly reach out to employees of Braddock's Smokehouse and encourage them to consider their complicity in the restaurant's operations. She had apparently compiled a list from our staff's public social media profiles. Patrice, my waitress, called me on a Sunday night. I could hear the tension in her voice. She is not easily rattled, but she was rattled. "Someone left a pamphlet under my windshield wiper, Gideon. My kids were with me. I don't want my kids in the middle of this." Theo texted me 2 hours later. He'd received a direct message on Facebook from someone he didn't know, telling him his employer was on the wrong side of history and encouraging him to seek other employment. He had already blocked the account, but he forwarded me the screenshot. His message to me had 3 words: "We good here." I drove to the police department the next morning, not the non-emergency line this time. I went in person and sat across from Detective Sharon Burrell, who handles civil harassment cases for the county. I brought the pamphlet, Theo's screenshot, Patrice's account, and a typed summary of every incident over the past 6 months. Detective Burrell read it methodically, asked good questions, and then looked at me. "This crosses from protest into harassment of private individuals," she said. "Specifically, the targeting of employees at their personal residences." She opened a formal file under Ohio's civil stalking and telecommunications harassment statutes. She also reached out to the Millhaven Ethical Consumption Alliance's registered address, which was Cordelia's home address, with a formal notice that further contact with private individuals associated with Braddock's Smokehouse would result in criminal charges. Takeaway: when a harassment campaign shifts from targeting a business to targeting individual employees at their homes, it crosses from civil dispute into potential criminal territory under most states' stalking and harassment statutes. The police notice had an immediate effect. The pamphlet stopped. The social media campaign against staff went quiet overnight. But behind the scenes, we were in full preparation mode for April 12th. Nadine had put together what she called the complete picture, the anti-SLAPP evidence package. It included the full timeline of Cordelia's administrative complaints and their dismissals, the Millhaven Gazette false statements and the correction record, the Oregon Red Timber case documentation showing prior similar conduct, the financial records from the National Compassion First Coalition, including the strategy document and the wire transfers, Boyd Calloway's sworn affidavit, the police report from Detective Burrell's office, our 17-page EPA-compliant emissions report, our revenue decline data with POS documentation, and the lease clause protecting our display case. The package was 340 pages. Nadine also pulled together something called a Daubert motion, a challenge to the admissibility of Cordelia's claimed expert witness, a nutritionist from Columbus, whom Cordelia's team had planned to call to testify about the documented health effects of exposure to meat odors. Nadine's motion argued the witness had no peer-reviewed research on the specific claim being made, that the scientific literature did not support the causation being alleged, and that the testimony would therefore not meet the evidentiary standard for expert witnesses. Judge Voss granted the motion in a terse, two-paragraph order. Cordelia's expert was out. Reed Albright filed a request to continue the April 12th hearing, claiming he needed more time to prepare. Judge Voss denied it. She had been on this case for 4 months, and her written denials had been getting progressively shorter. That's usually a sign. April 11th. Braddock's was full. Our Friday regulars, Prentice Holloway eating his brisket sandwich, Eugenia Wakefield having dinner with her book club, Boyd Calloway driving in from Knox County specifically to eat with us the night before the hearing. The air was warm for April, and we had the side door propped open, and there was the smell of charcoal and the sound of people talking and the clink of sweet tea glasses. Theo closed down the smokers at 10 p.m., wiped down the grates, and stuck his head in my office on the way out. "You ready for tomorrow?" "Yes," I said, and I actually meant it. April 12th. The hearing was scheduled for 9 a.m. in Courtroom 4 of the Millhaven County Courthouse, a high-ceilinged room that smells of old wood and carpet that hasn't been replaced since the Clinton administration. The gallery seats about 60 people. By 8:45 it was full. The Friends of Braddock's Facebook group had coordinated. Eugenia Wakefield had organized a carpool. Boyd Calloway sat in the front row of the gallery in a barn coat, looking like he had driven through rain to be there, which he had. Patrice was there. Theo was there in a button-down I had never seen on him, looking very composed. There were people I recognized from the community cookout. There were people I'd never met who, it turned out, had eaten at Braddock's for decades. There was a reporter from the Columbus Dispatch and one from a regional news radio station who had a small recorder on his notepad. Cordelia Fitch came in with Reed Albright. She was dressed in a fitted blazer and appeared, from across the room, very certain of herself. Albright set a slim folder on the plaintiff's table. Nadine's table had a thick, organized binder, tabbed and color-coded. The physical comparison of those two stacks of paper told a story before a word was spoken. Judge Harriet Voss entered from a side door. Everyone rose. She settled herself at the bench with the practiced efficiency of someone who has done this 10,000 times. And she said, "We're here on defendant's motion to dismiss under Ohio anti-SLAPP statute, Section 2923.14, and defendant's counterclaim for tortious interference. Counsel may proceed." Nadine went first. She was calm and clear and moved through the evidence the way a surgeon moves through a procedure. No wasted motion. The timeline, the dismissals, the Oregon precedent, the Compassion First Coalition financial records, which she projected on a screen so the judge could read the strategy document, line by line. She quoted directly from the wire transfer memo. Legal Action Initiative, Millhaven, Ohio. She walked through our revenue decline. She placed the lease clause on record. She was finished in 22 minutes. When Reed Albright stood to respond, he looked, for the first time in this entire proceeding, uncertain. He argued that the lawsuit represented a genuine, good-faith belief in illegal harm. He argued the plaintiff's First Amendment rights were implicated. He argued the counterclaim was an attempt to chill activism. Judge Voss let him finish. Then she asked 2 questions. "Counsel, is it your position that the plaintiff was unaware of the prior dismissed litigation in Oregon when she filed this complaint?" Albright hesitated. "I cannot speak to the plaintiff's awareness of—" "Counsel," Judge Voss said, not unkindly but with the finality of a door closing. "I have the Oregon case file in front of me. The plaintiff was the named plaintiff in that case. She signed the complaint. Are you representing to this court that she did not know? Silence. Judge Voss asked her second question. And the wire transfer memo from Compassion First Coalition, the document titled Legal Action Initiative, Millhaven, is the national organization prepared to take responsibility for this litigation? Albright said the national organization was not a party and could not be spoken for. They are now, said Judge Voss, not loudly. She looked down at her papers for exactly 5 seconds. Then she looked up. This court finds the complaint fails to state a claim upon which relief can be granted. Further, under the evidence presented, this court finds this action constitutes a strategic lawsuit against public participation, as defined under Ohio Revised Code 2923.14. The complaint is dismissed with prejudice. Defendant's motion for attorney's fees is granted. Additionally, based on the evidence of a coordinated external campaign and the pattern of conduct documented, this court is referring the matter to the Ohio Attorney General's office for review of potential organizational harassment violations. We are adjourned. She banged the gavel once and stood. The gallery was quiet for about 2 seconds. Then Boyd Calloway started clapping. Not a polite courthouse clap, a full, deliberate, cattle rancher clap that bounced off the wood ceiling. And then everyone else joined in, and someone in the back said, "Yeah!" And Patrice grabbed my arm, and Theo stood there with his eyes a little bright. And I thought about my grandfather and his cast-iron smoker in the driveway, and I did not cry, but it was, I will be honest, a near thing. Cordelia Fitch left through a side exit without a word. Reed Albright, to his credit, nodded to Nadine on the way out. It was the acknowledgement of a professional who knows when he backed the wrong client. The Columbus Dispatch reporter was already typing. Here's how it settled out. Judge Voss's attorney's fees award came to $47,200, covering Nadine's fees and Walt's consultation costs over the entire proceeding. The court entered judgment against Cordelia Fitch personally, and the Millhaven Ethical Consumption Alliance jointly. The National Compassion First Coalition, facing the Ohio AG referral, negotiated a consent agreement within 60 days that included a $25,000 civil penalty and an organizational policy prohibiting funding litigation against private businesses, a precedent-setting agreement that Nadine told me she'd never seen come out of a case this size before. Cordelia and the Millhaven chapter were required to issue a written public correction of the factual inaccuracies in their social media campaign. The correction ran in the Millhaven Gazette. It was brief. It confirmed that Braddock's Smokehouse had never failed a health inspection, had never been found in violation of any city or environmental ordinance, and that the prior claims made to the contrary were inaccurate. Eugenia Wakefield printed it out and brought it to the restaurant. She taped it on the wall next to her own letter. I left both of them there. They're still there. Cordelia Fitch moved out of Millhaven within 4 months of the ruling. I don't know where she went. I genuinely wish her a quieter life somewhere, because whatever pain drives a person to spend 18 months systematically trying to destroy something that belongs to other people, that must be an exhausting way to exist. I have thought about this more than once, and that is the honest conclusion I come to. Anger is one thing. That was something else. For the restaurant, our revenue in the 6 months after the ruling was 22% higher than the comparable period the year before. Some of it was the community response. Some of it was the Columbus Dispatch story, which ran nationally on a slow news weekend and generated coverage we could not have bought. A lot of it was just people who'd heard about Braddock's and wanted to come see it for themselves. Theo hired 2 additional staff. We expanded our outdoor patio seating by 12 tables. And here's the part that means the most to me. The community fundraiser that Theo organized, the Smokeout, the Pay What You Can lunch, ended up raising $4,200 for the Millhaven High School Culinary Arts program, enough to buy a commercial convection oven for the teaching kitchen and fund 4 student spots at a regional culinary competition. We made it annual. The second Smokeout, held that fall, raised $7,100. The third one raised $11,400. We added a scholarship component, the Wendell Braddock Memorial Scholarship, $1,500 per year, to a Millhaven High School student pursuing culinary or hospitality education. The first recipient was a 17-year-old kid named Marcus Sills, who wants to open his own restaurant someday. He came in on a Saturday to say thank you, and Theo put him to work trimming a brisket for 2 hours and gave him a full ship's pay. Marcus comes back every Saturday now. We might have ourselves a future pitmaster. That, if you want a summary, is what Cordelia Fitch tried to bury. Not just a restaurant, but the mechanism by which a community invests in its own future. She failed. We didn't. Here's what I want you to take away from all of this, practically speaking. If someone is using administrative complaints, manufactured media pressure, or a lawsuit as a harassment campaign against you, you have tools. Anti-SLAPP statutes in over 30 states, tortious interference claims, discovery rights, police reports for targeting private individuals. Keep records from day one. Find an attorney who knows these tools, and rally the people who actually know and care about what you've built, because they are more powerful than any outside campaign.
You know what stays with me about this one? It wasn't the hearing. It wasn't even the moment the board backed down. It was the fact that Marcus had every single page of those bylaws before he ever sent one email. Every page. Most people never do that. Most people react. And that's exactly what these boards count on. That $1,200 fine they handed him wasn't even real about the fence. You probably already figured that out. It was a test. To see if he panicked, write an angry letter, say something they could use. He didn't. He just went quiet and got to work. That's the part that's hard to teach somebody. I've heard a lot of these stories, more than I expect to when we started this channel, honestly, and they follow a pattern that gets pretty familiar after a while. But every now and then one comes along where the person on the receiving end just refuses to play the game the way it's designed, and something shifts. This was one of those. If you've been through something like this, a fine that didn't make sense, a rule that seemed to appear out of nowhere, a board that just wouldn't let something go, I genuinely like to hear it. Drop in the comments. Not looking for outrage, just the sorry. What happened? How did you handle it? If this one meant something to you, share it with someone who's dealing with an HOA right now. Might be exactly what you need to hear. We'll go back with another one soon.